The notice of rights of an alleged incapacitated individual. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover this particular SCAO form, State Court Administrative Office Form PC626. This form was amended in July of 2024, replacing the outdated and earlier used forms. It is a form used in a very particular context, which is a petition for guardianship of an adult alleged incapacitated individual. It's used in Michigan, and the form itself is served by the guardian ad litem to the person that is alleged to be incapacitated. The court appoints a guardian ad litem after the filing of the petition for guardianship and before the hearing to do a report and investigation. This form, which is to advise the legally incapacitated person or the alleged legally incapacitated individual of their rights now that a petition is being sought for guardianship over them. In the purple box, you'll see the statute that's relevant to this particular provision. It is 700.5306A, and it is a two-page document, and let's work our way through it. As you'll see at the top of the document, it requires the court address to be identified there. The idea being that the guardian ad litem or another person would complete this form for purposes of then serving the alleged incapacitated individual to give them notice of where the court is. In addition, it identifies that a petition has been filed with the court asking for the appointment of a guardian to help make personal decisions and on that person's behalf. If a guardian is appointed, they will make the decisions such as medical care and could also decide and determine where you live, and that the guardian will be responsible to get services for you, the individual who is being sought guardianship over. The notice states that you have certain rights, and the idea is that we don't want this vulnerable population to have a petition for guardianship filed without them understanding the rights that are at play. And a guardian ad litem, to be differentiated from a guardian, a GAL gets appointed by the court to explain those rights to the individual. They're obligated to do a visit in person to explain the nature and purpose and legal effects of the appointment of a guardian, to inform you that they have the power to do a do not resuscitate order relating to treatment, explain your rights as to a guardianship proceeding, whether you want to accept the petition for guardianship, whether you want to object to the guardianship, or maybe the person that's being sought as your guardian, and informing you of how that objection would look. What are your rights under the guardianship petition to object to either the person or the guardianship itself, as well as the standby guardian that is now available for a guardianship petition for an adult. The big change between this form and the prior form really relates to this addition in Michigan law of a standby guardian that can be requested. It says in bold letters you have certain rights before and at the court hearing on the petition to appoint a guardian or to designate a standby guardian for you. You have the right to have the guardianship case started and conducted where you reside or are present, or if you have been admitted to an institution by a court in the county in which that court is located. In addition, you have the right to file a petition on your own behalf for the appointment of a guardian or the designation of a standby guardian. You have the right to be represented by an attorney, and if you can't afford an attorney, you may ask the court to appoint one for you at the public or government's expense. You have the right to a guardian ad litem appointed to represent you if you're not represented by an attorney. You have the right to an independent evaluation. So this would be an evaluation as to either your physical or psychological or psychiatric or all. If you are unable to afford that evaluation, the court will pay for the reasonable cost of that evaluation because there's a burden for the person to show by clear and convincing evidence that there's a need for the appointment of a guardian. You have the right to be present at the hearing. Wish to be present, all practical steps will be taken to ensure that you can be present at that hearing on the petition for guardianship. And then you have the right to see and hear all the evidence that's presented against you or in regard to this petition for guardianship. You have the right to present evidence and cross-examine witnesses, or your lawyer could do so, and you have the right to a trial by jury. Yes, you have a right to a trial by jury on a petition for guardianship. On the back of the document, it provides you the right to request the hearing be closed to the public so you can have privacy in relation to the petition, and you have the right to be personally visited by the guardian ad litem if one is appointed. You have the right to be informed of each of the persons that are being asked to be appointed as your guardian or designated as your standby guardian. And if a guardian ad litem is appointed, you have the right to be informed of these names by that guardian ad litem. You have the right to be given written notice of the nature, purpose, and effect of the appointment of a guardian, so you understand why a guardianship and the rights that a guardianship would have over you. You have the right to choose the individual you would like to serve as guardian. So just because the petition nominates somebody as guardian doesn't mean that that is the end of the discussion. You have the right to actually nominate who you'd like to serve, so you can specify to the court who you'd like to be appointed as your guardian and or standby guardian. Now, of course, they have to be suitable and willing to serve. You have the right to have your incapacity and the need for guardianship be proven by the burden of clear and convincing evidence. So it's a large burden that you can require that the petitioner has to climb over for purposes of satisfying the requirement. And then you have certain rights after the appointment of a guardian. So all of these rights speak about before the guardianship is imposed. These rights refer to after the appointment. You have the right to object to the appointment of the successor guardian by will or other writing. You have the right to the guardian's powers and the time period for which the guardianship may be limited to only the amount that's necessary. So the idea is that if there's a guardianship, the court should limit the guardianship to the extent that you need assistance. You have the right to have a guardianship that encourages the development and maximum self-reliance and independence. The idea is that the guardianship should not diminish your right to self-reliance. It should give you as much autonomy and freedom and maximum self-reliance as possible. You have the right to prevent the guardian from having powers that are already held by a patient advocacy. This is a medical patient advocacy where it's like a power of attorney for medical related decisions. So if you already have one in effect, the court should be aware of it. You have the right to periodic review of your guardianship of the court, and you have the right to send, even at any time, an informal letter to the judge asking for a modification. So the idea is that you're vulnerable, and if you're vulnerable, there should be a pretty low bar to bring it to the court's attention. You could simply write a letter and ask the court to have a modification or termination of that guardianship. You have the right to hearing within 28 days of requesting a review, modification, or termination of the guardianship. And if there's a petition to do so, you have the same rights as set forth in this particular notice. You have the right to get personal notice of a petition to appoint or remove a guardian. So you have the right to that information if that request is being sought. And you have the right to consult with the guardian about major decisions affecting you. So major decisions should be consulted with the guardian. If the guardian doesn't want to be involved in those decisions, you should bring it to the court. If meaningful conversation is possible, then you have a right to that conversation. And you have the right to be visited by the guardian at minimum once every 3 months. It can be a guardian or a representative of the guardian entity. You have the right to a guardian to notify the court within 14 days of a change of address. You have the right to the guardian to secure services to allow you to be in the best possible state of mental or physical well-being, and you have the right to the guardian to take reasonable care of your clothing, furniture, vehicles, and other personal effects. So again, the idea is that you're given notice of all the rights both before the guardianship imposed as well as after. At the Probate Pro, we are passionate about everything probate. If you have questions about this notice of rights to an alleged incapacitated individual or any probate-related issue, visit us at theprobatepro.com or call us at 833-PROBATE.